Good afternoon, everyone. My name is Tamina Ahmed. I am in the Woodland Hills office, which has recently been relocated from Tarzana. I am the managing partner for client relations, and I've been with the firm for almost 23 years now. And prior to that, I worked in-house at Fremont Compensation. Some of you may remember. I am so pleased to be here with Zane and Gemma and Rob Sifkis, as well as my marketing team, and Don Barthel. This is our second presentation of the year, and we hope you enjoy it. We know there's a lot of regulations out there for employers and for adjusters. We want to partner with you on any questions that you may have and any assistance you may need. We know the claims are coming in fast and furious these days, so please let us know how we can help. You can reach us at any time on our cell or email. Thanks so much for having us. Gemma?
Hi, my name is Zane Uribarri, and I am in the Ontario office. I have been with the firm for about 10 years, and I'm currently the assistant managing attorney of my office. And like Tamina said, we're just happy to be here, and if there's anything that we can do, please don't ever hesitate to email us or call us at any time. I will hand it off to Rob.
My name is Rob Sifkis, although it indicates William. Many of you know me as Rob, but it's William Robert. I'm sure I've worked with many of you in the past, although I've been with Bradford and Barthel for 7 years, been practicing workers' comp defense for over 25, predominantly in the Southern California area for many years, covered all of the boards in Southern California, and recently have moved to our Northern California office up here in Redding. So we cover Sacramento, Redding, Eureka. So if anyone has any questions about specific at those boards, or if they've got questions regarding doctors in the Northern California area, feel free to give me a call. I'll be happy to answer anything. I look forward to working with everyone, and I'll pass that off to Zane.
I want to go ahead and let Don is on. Let Don introduce himself. Don?
Oh, this is Don Barthel with the dogs barking in the back. I apologize for that. I'm one of the founders of Bradford and Barthel, and we're a statewide defense firm with offices throughout California. We've got about 100 attorneys who appear and represent employers and carriers and TPAs at literally every WCAB district office in the state. I want to thank you for joining us this morning, finding time in your busy schedules to learn about this fascinating and sometimes incredibly frustrating topic. You're in for a real treat with Zane today. By the way, please join me in congratulating him. He was made a partner of Bradford and Barthel yesterday. So great job, Zane. That partnership is in no small part due to the amazing job he does with these presentations. He's one of the founding members of our highly successful B&B COVID-19 task force. And this group is dedicated to keeping employers, carriers, TPAs, and really the industry in general up to date in the latest COVID changes, whether they be executive orders, statutes, regulations, case law, the like. The task force actually has handled hundreds of COVID cases, ranging from basic fact patterns to many death cases. And we are the exclusive COVID-19 defense rep for some large statewide and national employers. Tammy mentioned the B&B blog. Zane and his crew have presented dozens and dozens of webinars and published many articles regarding COVID. And these can be found on our website at bradfordbarthel.com. And many of them have been republished on Work Comp Central because they've seen the folks at Work Comp Central have determined that they're so valuable that they need to make sure that the entire industry sees them. After today's presentation, if you have a file that needs representation by our informed, aggressive team, please contact us at covid@bradfordbarthel.com. That's covid@bradfordbarthel.com. And this contact information is also available on our website. Of course, if you have any questions, by all means, feel free to call us. And so, without further ado, let's have Zane take the lead. Zane?
Thank you, Don, and good morning or good afternoon, everybody. I guess here we are right at the lunch hour, probably enjoying your lunch, and what better way to wash that down than with an ocean of OSHA regulations. And yes, that is the kind of bad dad joke that I am known for and that my 4 kids really can't stand. But we're going to go ahead and dive right into some of the new OSHA regulations and some of the new statutes that have been passed and that have gone into effect. Specifically, AB 685 made some amendments to some new labor code sections, put in some laws that are going to be in place for the next couple of years and then will sunset, and some different ways to deal with COVID-19 in the workplace. So we're going to look at those. We're going to look at what the regulations themselves actually say, how those are going to apply. Please do ask questions. There is a method for asking questions here during the webinar. We will get those read out. We will answer them to the best of our ability. Also, if you submit questions later, completely fine. As Don said, covid@bradfordbarthel.com. That's the email address that you want for all of your COVID-related questions. Go ahead and send those in to us. So this new section that was passed has a lot of different reporting requirements for employers. There was a lot of amendments made to 6325, adding in a new section that became effective January 1st and will run until January 1st, 2023. And this is related specifically to different measures that need to be taken to protect employees with respect to COVID-19. There were some different amendments that also required notification about available benefits that employees might have, and some amendments regarding disinfection plans, safety plans, notification plans, how to communicate with employees, and so forth. So we'll be kind of looking at all of that as we go along. One new interesting thing, and this is a question that comes up a lot, is what exactly ends up being a workplace, or what ends up being a place of employment when we look at COVID exposure. If there's been exposure in the workplace, then all these new laws and regulations kick in, and kind of what is the definition of that? It's defined as a building, a store, facility, agricultural fields, because we do have questions that come up regarding farming, and other places where an individual may have worked while they were infected. It does not apply to locations such as buildings, floors of buildings, where an individual that had COVID-19 didn't work or didn't go. So that is a question that we commonly get. We will be touching on that later, but I did want to just go ahead and touch on that right now. So next, what we're going to look at is some amendments that were made regarding what is a serious violation. And if OSHA determines that there has been a serious violation in the workplace, what happens next in terms of making that determination? If there is a serious violation, that means that they have made the determination there's a realistic probability that death or serious physical harm may occur due to the violation. And for this particular section, this is specifically related to COVID. There are other sections that were related to other machines in the workplace or other conditions, but this is specifically related to COVID. So OSHA will look at preventative training, which included ways of preventing exposure to COVID-19, discovering what the particular hazards were at a place of employment, what actions the employer took to correct those hazards, and then how that was communicated to employees about the particular hazards, and the extent that employees were able to communicate those hazards back to the employer. That is also something that is looked at. That is something that is detailed in the new COVID regulations themselves. So if there is a serious violation, though, that is found, there is also this investigation into whether or not the employer took reasonable steps given their particular set of circumstances to anticipate, to prevent the particular violation, and considering the severity of harm that may have occurred, in this case COVID-19, what were the steps that were put in place to prevent the violation from occurring. The reason that this is something that we want to look at is because it's not only important for the employers to be compliant with Cal OSHA regulations, it also does affect workers' compensation claims in that it could end up affecting a serious and willful claim that is brought at a later time. The serious and willful claims will allege that there were violations of statute or violations of regulation that led to COVID being more prevalent in the workplace, and thus employees were a little bit more exposed, or at least that is the claim. We are starting to see more serious and willful violations being filed now on COVID cases that were filed as workers' compensation claims about 5 or 6 months ago. And this may be due to the fact that individuals who were perhaps quite ill at the time that they contracted COVID, and maybe even at the time they filed their claim, have really recovered well. And some of the QME reports that we are beginning to see have their permanent disability at 0. So I think applicant attorneys are starting to get a little bit, they're starting to look for other ways that maybe they can file a claim or maybe change the value of a claim. So serious and willful claims are something that we do want to keep in the back of our mind, in addition to complying with the COVID regulations themselves. So next, what is interesting about these COVID regulations is that they were issued prior to AB 685 taking effect. And AB 685 was the bill that was really put into place to try to protect workers. It was a bill about having to report COVID-19 in the workplace, what you had to communicate to employees and when you had to do it. And these OSHA regulations came out on November 30th, and they went ahead and they put the regulations out, citing some other statutes that allowed them to do that, because AB 685 itself didn't take effect till January 1st. And it does look like OSHA just wanted to get these new regulations out and rolling right away. So some of these new definitions that have been put in place through the Cal OSHA regs, we're going to go through those, what they mean, but really the Cal OSHA regs are implementing the different changes that were made in AB 685. Gemma, did we have a question?
We do. We have one question so far. Do these amendments apply both to private and the public sector?
These amendments, as we will see, these regulations, they apply to employees, and they don't limit the type of employers that they apply to. There are a few exceptions that we will look at, but in terms of who these are applying to, there's no limitation as to what kind of employer it does apply to. Under the exception section, there may be some different opt-outs, and if you do have a specific question, email that to us, or if it's put into the chat, we can look that up actually and figure out whether or not a particular employer or employee is subject to an exception, and answer it that way. But much like SB 1159 that applied to everybody, these regulations are also going to largely apply to everybody. These regulations did go into effect rather quickly, and they were done so with very little public discussion and comment. There are already 2 pending court cases, one in San Francisco and one in Los Angeles, challenging the regulations. I know some employers are saying these are very burdensome regulations. These are very difficult, especially in terms of trying to track where individuals have been, who they may have come into contact with, especially in larger or busier workplaces. That can be quite a difficult thing to do, and the regulations have been challenged on that basis. But even if the challenges to the regulations are successful, the regulations can simply be put back in by going through the right administrative procedures. So really, these are going to be the rules going forward, one way or the other. So now we're going to go ahead and look. Oh, Gemma, we got another question. All right, here we go.
We do. We have another question. Are these regulations retroactive to the November date?
They became effective immediately when they were issued on November 30th. So even though AB 685 didn't come into effect until January 1st, these regulations went into effect right away. It also should be noted, and I'll get to this a little bit later, but the regulations came out when the governor read them and then decided to make some changes. So on December 14th, he issued an executive order that makes changes to the regulations. So there is a lot happening. I did check this morning to see if he issued any new executive orders, making any more changes, and nothing so far today. But you never know when something new is going to come out or something new is going to change. But those regulations did go into effect as soon as they were issued. So let's look at the regulations, what they are, and who specifically they're going to apply to. And we just touched on this a little bit. We can go to the next slide. They apply to all employees, and they're going to apply to all employers unless they meet one of the exceptions that is listed below. So one of the exceptions that is listed is individuals that are solely working from home. If you're just working from home and only working from home, the Cal OSHA regs are not meant to regulate your particular home. They're meant to regulate the work, your work site, when you have to travel and go to a place of employment to do work, even if that's a location that maybe isn't owned by the employer. So as long as you are not solely working from home, then these regulations are going to apply. The regulations also don't apply to employees that do not have any interaction with anyone else. I was asked a question about an employer that employs farmers that work by themselves, have their own equipment, and they do literally work in a field, but they don't have any interaction with anyone else. That would be a good example of somebody that doesn't have any interaction with other people. It is interesting that these regulations talk about interaction with other persons and not just other employees. For those of you that know, AB 1159, which has the COVID outbreak presumptions for workers' compensation, looks at the number of employees that have contracted COVID-19 and ignores things like third-party vendors that come into the workplace and also ignores members of the public. These regulations do not do that. So these regulations will apply if you have one employee who is at a single location working by themselves, who only interacts with the public. These regulations would then continue to apply since they apply to anybody that has any interaction with other persons. And then finally, there's going to be an exception for individuals that are already covered by another regulation, which is 5199, largely healthcare individuals and largely healthcare providers. In that case, these regulations are going to be applied in a very fact-specific way. And to determine whether or not one of the exceptions applies, it's also going to be a very fact-specific analysis. So to determine whether or not maybe some of the areas of the medical field don't apply, you'd have to look very specifically at the individual's job title, their job duties, what it is they do, look at the exceptions that are under 5199, and then make that determination. That may not be easy because the categories are a little broad and vague, but if you do fit into one of those categories, then all of these regulations then would not apply. So now we have another question.
We do. Where you have an employer that where 100% of the time the employee works from home, but they do go to the place of work to exchange files or documents, do the regs then still apply?
So the regulations would apply then because you're going to have a lot of hybrid situations where individuals work part of the time at home and then part of the time they have to go into a physical office. The regulations will apply even if they have the option to go into a regular office or place of employment. They're not required to, but they can. If they do go in, then they're going to be considered to be working at that particular place of employment. If there was a COVID case that occurred there, they would have to be notified. If they were themselves a COVID case, then others that they came into contact with in an exposed workplace, those individuals would then also have to be notified. This is somewhat similar to what happened with the COVID presumptions for workers' compensation. We have individuals that are sometimes working from home and sometimes they are going to their place of employment. So to the extent that it is that hybrid situation, you do have to consider them to be working at the place of employment when they are actually doing that and not just solely working from home. So the regulations have kind of left us with, and we can go on to the, we can go to the next slide. We have a whole bunch of new legal terms here, and these are all now new terms of art. The regulations are going to refer to an individual who is sick as a COVID case, and then they will do that throughout. They will define what is a COVID test and a COVID hazard, and the high risk exposure period, which turns out to be an important time frame that you have to look at when making a determination about who you have to tell in terms of other employees or vendors that there was a COVID-19 case that occurred at a particular place of employment. So let's go ahead and look first at what a COVID, at the first term here, which is, well, what is a COVID case and how the regulation has defined what is a COVID case. A COVID case is an individual who has tested positive for COVID-19 or is subject to a related order from a government health official. You're going to find throughout these regulations that either a set of factual conditions has to exist for the regulations to kick in, or there has to be an order from a government health agency. And that applies to almost every part of the regulations. If there is an outbreak, there may be one because of factual circumstances, or one may simply be declared by the local health department. The local health department can also declare that the regulations apply or don't apply in a particular circumstance. And pursuant to the governor's executive order, local health agencies can shorten the time periods for employees to return to work. So we'll get into that and we'll kind of see that, but you will see that these are the rules that apply unless a local health agency or a state health agency has said something different. So a COVID case is an individual who is ill, who has been ordered to isolate, or an individual who has died from COVID-19 if it's been determined that that was actually their cause of death. It's a necessary first step to make sure that there was a COVID case so that we know that the rest of the regulations then have to kick in. Once there is an individual who has identified as being a COVID case, we look at the rest of the regulations and then what has to happen next. And you continue to be a COVID-19 case until a healthcare provider basically says that you are not. Exclusion from the workplace has one definition and one set of rules, and then whether or not you are still considered to be an individual who has COVID-19 is a determination that is made by your doctor. It's not a determination that is made by a negative test. And this is an interesting part of the regulations. A negative test is not required in order for an individual to return to work. Gemma, another question?
Yes, so the question is, does every COVID positive employee require a clearance note to return to work?
And as we'll look into the regulations, and the regulations are divided up by section, most of the regulations are under section 3205. And then in order to return to work, we have to look under subsection C11, and that lists the requirements for an individual to go ahead and return to work. And those requirements are that they no longer have a fever within the last 24 hours, that their COVID-19 symptoms have improved, and that it's been at least 10 days since the onset of symptoms. That 10 days can be reduced by a local health agency. They may make it 7, they may make it 5, they may have some other mandates in place. But in order for someone to return to work, those are the requirements that are spelled out in the return to work requirements in the regulations that we'll see a little bit later on. An individual may not be actively, an active COVID case because they may have been discharged by their doctor already. There are just different return to work requirements. And it should be noted that OSHA and the CDC and at times the different statutes that are passed do not agree. So there is some confusion there. And if there is specific questions regarding that and which rule would apply, there's usually a way to figure out which rule would apply, and we can also help you with that. So after you've determined whether or not there's a COVID-19 case, then we move on to COVID testing. And COVID testing is going to be required in a lot of these cases. If an individual has tested positive at the place of employment, then testing of other employees is something that needs to be offered. But when we look at what is defined as a test here, for the purposes of these regulations, it just says a test that is approved by the FDA. It does say that it has to be a viral test, but it doesn't specifically state that it has to be a PCR test, as we saw with SB 1159. We've now seen this new rapid antigen test that is being put into place. Some employers are providing it on site, and if you test positive using that test, that would be considered a positive test for purposes of these regulations. As long as it is an approved test by the FDA, then it's going to go ahead and apply, even if that's a test that cannot be used to show a positive case in the workers' compensation world, since they do require that PCR test itself. The antigen test is fairly new because it was just approved by the FDA for use in mid-December. So it's something that we're starting to see a lot more of. We're starting to see more of those kind of positive tests because the results are quicker, and in certain cases they can be done on site by the employer. Please note, though, that a test is not an antibody test. That is still not a positive test for purposes of the Cal OSHA regulations or any other regulations. So next, we have to look at whether or not there's been exposure to COVID-19, and of course, we get ourselves into a very technical and somewhat arbitrary definition of what exactly exposure is. Sort of the long and short of it is that being exposed to COVID-19 means that you are within 6 feet of a COVID-19 case for a total of 15 minutes in a 24-hour period of time. That 24-hour period of time is going to overlap with what's called the high-risk exposure time frame, which we'll look at, but that's the time frame when an individual has either had symptoms or has tested positive, and there is kind of a window there. But what we're looking for is that particular window, that individual, who else were they around? Was there exposure to COVID-19? And we have to look at this very exacting definition. Also, that is somewhat arbitrary, which is a contradiction, I guess, in terms, but within 6 feet for a total of 15 minutes within a 24-hour period of time. We can go to the next slide. We want to look at what a COVID-19 hazard is and what may potentially constitute a COVID-19 hazard. A COVID-19 hazard is anything that spreads COVID-19, and largely this is going to be airborne particles, aerosol particles that almost exclusively come from people through exhaling, talking, sneezing, coughing, anything like that. Anything that would help transmit respiratory fluids essentially is going to be considered a COVID-19 hazard. These regulations also state, though, that anything that might also have those particular particles on it, such as surfaces where individuals may have been touching the surfaces or may have coughed and contaminated a surface, those also have to be considered COVID-19 hazards. And it's important to figure out what a hazard is, since employers are required to identify hazards. They are required to figure out what it is they need to do in order to abate a particular hazard and reduce the possibility of infection. So now we'll look forward and see what an exposed workplace is and what are the requirements to have an exposed workplace. And that's going to be an area or location where an individual that has COVID-19 was working during their high-risk exposure period. That high-risk exposure period, just to let us know, it's 2 days before symptoms began for an individual till 10 days after the symptoms began. And normally someone's not going to still be at work 10 days after their symptoms have begun. But that exposure period is largely going to be the 2 days before their symptoms began, and maybe the day their symptoms began, then they go home, they get a test, and that's the period of time that you're looking at. Where was the individual? What were the exposed areas? What places were they working at? What floors were they working at? What locations were they at if they go to multiple locations? That helps the employer know who it is that they have to inform in terms of informing other employees, and then also to figure out, did that individual get COVID-19 from a particular place of employment? Gemma, another question?
Yes, along these lines, if there is a barrier between employees within their work area, in addition to them wearing masks, is that still an exposure?
It can be considered a hazard. What the regulations want you to do as the employer is look at the protective measures that have been put in place. First, you have to establish what those protective measures are. Those are going to be very, very employer specific because what works for a retail outlet will be different than what works for a restaurant, will be different than what works for a smaller store with one employee. So to the extent that you have in place a cleaning schedule, certain employees have to wear gloves, all employees have to wear masks, and there are physical barriers that are up, and the actions and measures have been taken to reduce the possibility of the spread of COVID-19 as much as possible, then you're looking at a situation where you're in compliance with the rules. Then when there is a case of COVID-19 in the workplace, someone has tested positive, the employer has to check and has an affirmative duty to check and see if any of their protective measures that they were using were in any way deficient or could be improved. One question that we have received a lot is, well, what if the individual became ill and they say, well, my spouse was ill first and then they became ill and then that's how we ended up here with a case of COVID-19 in the workplace. Well, in that case, none of the particular protective measures that the employer put in place failed. There was no additional hazard in the workplace that needs to be corrected since the infection came from a non-work related source. That kind of investigation would be rather quick. You have the admission from the other individual that at home they were around someone who had COVID-19, and of course at home you don't use masks, you don't social distance, there's not as much cleaning going on, definitely no physical barriers. So the protective measures that are put in place are designed to reduce the spread of COVID-19, and to the extent that it actually does that, then no changes would have to be made as you see that those measures are actually being effective. So I did want to reference AB 685 at this point because it has sort of broadened the definition of what a workplace is and kind of expanded the idea of what might be a workplace and what might not be a workplace. And it can be difficult, but fortunately we have a couple of different examples, some from the frequently asked questions site on Cal OSHA itself. If an individual only works on, say, the second floor of a building, then you're not going to have to consider the 12th floor of that building to be an exposed workplace. That is going to be different. Different floors of buildings are specifically mentioned as something that wouldn't be considered an exposed workplace if that employee didn't go to those exact locations. Also, exposed workplaces are going to be a lot of common areas. So restrooms would be considered a common area. Break rooms are also going to be considered a common area. Areas where time clocks are is going to be a common area. Not necessarily hallways where an individual might pass just once or twice a day. Entrances to buildings or entrances to work sites, not really considered a place of employment. That is somewhat explained by OSHA as well. If individuals are simply arriving to work and leaving work through the same area, that's not necessarily considered a place of employment. They're not there for very long. It's not considered to be a place where they are exposed. A little bit vague, I understand, and a little bit requiring some kind of analysis as to, well, are they there long enough? What about, is the entrance hallway doesn't count? What about the hallways between offices in an office building? You know, is that going to count? And it does make the analysis a little bit more fact specific and can make it a little bit difficult at times as well. Let's move on and look at the high risk exposure period, which is, I keep mentioning that term and probably should just move this slide up to the front as to what is a high risk exposure period. And it's the time frame where an individual who has COVID-19 presents a particular risk to the rest of the place of employment. And it has several definitions depending upon whether or not the individual was symptomatic or asymptomatic. If they have symptoms of COVID-19, then their high-risk exposure period is 2 days before the symptoms began until 10 days after those symptoms first appeared. So when an individual does become sick, say it happens on January 5th, we're going to be looking at the time and places that they were on January 3rd and 4th to determine who they interacted with, what work sites they were exposed to, in order to both inform employees at those locations that someone has COVID-19 and to determine whether or not there needs to be any changes to any of the safety procedures that have been put in place. That's why the high risk exposure period is important. It lets you know who to warn and it lets you know where to investigate. Also, if an individual does not have any symptoms, then it is the date of their test that becomes important, because we look at the date of their test and the date they tested positive. We go 2 days before that is their exposure period, and then 10 days after their test as the exposure period. That is a bit arbitrary. But it is simply the rule, and so since it is the rule, that's the time period that you have to consider, even though individuals may have been ill far earlier than simply 2 days before either they had their first symptoms or before they tested positive. Okay, we can go to the next slide, which is the COVID prevention program. And much of these regulations are about steps that the employer should take to prevent the spread of COVID-19. That's kind of the bulk of the regulations. What kind of steps they need to take in order to try to prevent COVID from coming into the workplace, what the requirements are in terms of communication with employees, evaluation of hazards, responding to hazards when there is a case, and use of personal protective equipment. And again, much of this is general guidelines, because an employer is going to have to come up with their own way of implementing those particular guidelines at a particular place of employment. It may be more difficult to do if there are hundreds of employees at one particular location. It may be more difficult to do in more crowded settings. And of course, different types of employment are going to require different types of rules. So, and just when you thought all of this would be easy, we did have that governor's executive order that came down on December 14th. It makes some modifications to some of the Cal OSHA regulations. It does make some modifications to some of the regulations with respect to farm workers and some of the time periods that they have in terms of when they can work and when they cannot work. But more specifically, what's going to apply to a great many cases is paragraph 7 of the executive order. It changes the amount of time that an individual must be off of work from the time that they first become a COVID-19 case. So when their symptoms start or when they have that positive test, they're supposed to be out for 10 days. If there is a local health order that says that they can come back sooner, then they can go ahead and come back sooner. Or if the local health department has other requirements for coming back, then those other requirements would then be followed. The executive order specifically allows local health officials to make different rules than Cal OSHA has gone ahead and put forward. So that is something else to keep in mind. You would have to check with those local agencies, and unfortunately, those local agencies are going to be different county to county. Los Angeles County's rules are very much going to be different than the rules that are, say, up in Northern California in Del Norte County. They will have very different rules and procedures in terms of how to prevent the spread of COVID-19. But when we start looking here at the bulk of the COVID protection program, one of the first aspects that's discussed is the communication with employees, the importance of communication with employees and what that entails. Employers have to have a system to communicate with their employees about the policies and procedures that they have put in place, such as a cleaning schedule, what kind of personal protective equipment they would have to wear, and whether or not there needs to be certain barriers or if there are changes to either a manufacturing process or a work process in order to protect them from COVID-19. Employers have to have a way of distributing this particular information. They also have to have a way of providing employees with information about testing if another employee has tested positive for COVID-19, and they also have to have a way of communicating that an individual has tested positive for COVID-19. So this information has to be communicated not only to the employees, so there needs to be a system set up for that, but employers also need to be aware of the fact that they have to communicate the existence of a COVID-19 case to other employers, persons, or entities that came onto their workplace during that high exposure period. So again, 2 days before symptoms began or 2 days before the positive test, and then going forward as much as 10 days, depending on the situation. This regulation initially says that the employer may have to notify other employers, persons, or entities. And at first blush, that could be slightly terrifying because persons implies this could be anybody that came into the work site. And if you're a place that is open to the public, arguably that could mean that you have to report to individual members of the public that they were also exposed to COVID-19. There is a later regulation, specifically subsection C3B3, which states that if there is a case of COVID-19 at the place of employment, the employer has to give notice of that potential exposure within 1 business day to employees, independent contractors, and other employers that were present at the workplace. So there's not a specific mention of having to tell either customers, members of the public, because that would become a nearly impossible task, especially for retail outlets where individuals simply walk in, walk out, and you may have no contact information for them at all. But the important thing to remember is you do need to communicate with the employees and also independent contractors or other employers that maybe had their employees at your place of employment in order to do work. So that's those are the individuals that need to be communicated with. Next, we'll look at evaluating, identifying COVID-19 hazards themselves. And that is a task that the regulations have just sort of left to the employers, but also allow the employees to participate in evaluating hazards. And the regulations also anticipate that employees will be able to communicate to employers potential hazards. This is why it's probably best to do this by email, your communication method, because you'll be able to disseminate information to your employees very quickly. And also you will provide an avenue for them to then respond back and say, look, I think that we're either working too closely in this particular circumstance, there needs to be a barrier, or if employees identify a particular hazard, the regulations require that they have a way of communicating that to the employer. So that is something that needs to be done. Part of evaluating COVID-19 hazards is to develop a process to kind of determine whether anybody has any symptoms. So employers can do things like ask about potential symptoms, conduct screenings. You're specifically allowed to do touchless temperature checks. Those are allowed. Just make sure that when screenings are being done, that you are asking questions about common COVID-19 symptoms, so it doesn't get too much into an individual's underlying medical history. So also under evaluating hazards, you may have to look at the types of ventilation and air filtration systems that are present. There are a few regulations that may require an upgrade to ventilation or to air filtration systems in general in a place of employment, especially with respect to particular types of work where individuals cannot wear masks while they are performing that particular job. We can go to the next slide, and the next slide is the investigation into COVID-19 cases and looking at what employers have to do once they have been informed that there is a particular COVID-19 case. And when there is one, there is information that they have to collect up. And it's important to remember several times during these particular regulations, and then also in conjunction with SB 1159, there is information that must be gathered and then communicated to different individuals. The information that must be gathered is usually different in each regulation and in each law, and who it goes to is different. So it's very important just to keep that in mind. For example, under SB 1159, when you're communicating with a claims administrator, you are informing them of a positive test, the date of the test, and the location where the testing happened, and the number of employees that were working in that at that place of employment. It's different under the Cal OSHA regulations. The information that you then have to collect up is very different. So you have to identify the date and the time that the individual tested positive. You need to determine the date of any symptoms, when those symptoms began, all the workplaces that, of course, they went to, and then you have to provide notice of that within 1 business day. But when you provide the notice, you can't provide any of the identifying information. When you communicate with the health department, you may be required to let them know the individual's identity and their contact information. So while all this information does have to be collected, it's not necessarily all going to be distributed out to everybody. We can go to the next slide. So what do we do next? Once there is a positive COVID-19 case in the workplace, the employer then has to offer testing. Testing has to be made available. It has to be made available during regular work hours and at no cost to employees. A common question here is, do the employees have to take the tests? And these regulations do not force an employee to take a test at this particular juncture when there is one positive case that is in the workplace. The testing has to be offered. If an employee were to refuse testing, then the employer should make sure that that individual is screened regularly when they are coming into work to determine whether or not they have any symptoms, and then therefore whether or not they should be excluded from the workplace. But the employer, once they have also offered the testing, they must then look at the workplace conditions and see if the workplace conditions contributed in any way to the spread of COVID-19. Did this individual become ill because there was a safety measure that was lacking, or because there was a safety measure that wasn't followed by the employees? So having the policies and procedures in place is good, but you also have to make sure that the policies and procedures themselves are being followed. Also, finally, an evaluation as to whether or not you can reduce the risks any further by any kind of further protective measures. And we can go to the next slide. Correcting a COVID-19 hazard and what an employer has to do in order to make sure that any unsafe or unhealthy conditions are appropriately addressed. You're required to look at that COVID-19 hazard and gauge whether or not it was a severe hazard, whether it's likely to be repeated, whether or not it can be changed. It is a very vague and sort of open-ended regulation. The employer is supposed to design policies to keep everybody safe. Then they have to evaluate whether or not their policies were actually effective, and then do that, keeping in mind the kind of work that they do and the type of business that they run. But employers are also required to provide training and instruction to employees on how to protect themselves from the spread of COVID-19. Including part of the notification that you have to do is not only on cleaning and the use of personal protective equipment, but also benefits that individuals may be entitled to under federal and state law. You have an affirmative duty to let them know about those particular benefits. Usually this information that you need to communicate can be all done, and it's not necessarily done in a boilerplate form, but a nice standard form that informs everybody that there was a COVID-19 case at a particular place of employment, and then what their benefits are, they have access to testing, and that kind of information, and laying that out in a standard form where then you plug in the date of the exposure and things like that would be very helpful. And it would be very helpful also to help get it out quickly, since you do only have that one business day. And we can go to the next slide. And here we'll look at physical distancing requirements. The regulations encourage individuals to work remotely. So they would like it if individuals worked remotely, if workplaces were less dense and had fewer people actually in them. They were very big on also making sure that there are visual cues that are around indicating when you are 6 feet away from maybe someone's workstation, or especially where members of the public should be standing, to identify what would actually be 6 feet away from someone else. So they do like to have those floor markings and other visual cues to help people out. There's also a suggestion of either staggered start and stop times for different shifts, but also staggering break times. One question that we commonly get is individuals may obey all of the social distancing rules and everything while they are working, but then when they all go to lunch, everyone takes off their masks and everyone sits around together, and then you end up with the problem where if someone is ill, they're likely spreading that in the break room, which honestly, for a lot of the COVID-19 cases that I have seen, is one of the main ways that it seems to be spread, is either in break rooms or in locker rooms or other places like that. So different types of policies maybe have to be put into effect there, and maybe staggering break times is something else that can be done. There are regulations, because we're running short on time, there are regulations on face coverings and when they do and do not have to be worn, to the extent that you come across a situation where an individual cannot always wear a face covering. They do have detailed regulations on that, and if you do have questions, we're happy to answer those as well. So next, other measures that might have to be put in place. Of course, we've talked about cleaning and disinfecting procedures that would have to go in. The regulations also discourage the sharing of equipment. And normally people will have some of their own equipment, but then there is some shared equipment. So making sure that there is cleaning before use or after use by different employees of common equipment would be excellent. And also the regulations have also taught us how to wash our hands, because 10 months ago, we all really didn't know how to do that. We didn't know how to do that very well. We can go to the next slide. Again, talking about personal protective equipment, at times respirators may be needed. We can go ahead and go to the next one. I want to try to get down to reporting a case. So reporting a COVID-19 case, within the Cal OSHA regulations here, they have to be reported to the health department when required to by law. You do need to know your local health department regulations in terms of when things need to be reported to the local health department. Those are going to vary greatly. So that is something else that you will definitely have to consider. Cal OSHA does need to be notified about serious injuries or illnesses. And that is a term of art that they have defined. So a serious injury or illness is an injury that has either some degree of permanent disfigurement, the loss of a limb, or an injury that requires inpatient hospitalization. Of course, also if an individual passes away, Cal OSHA does need to be notified about that. So those are the particular circumstances identified in the regulations where Cal OSHA does need to be informed, and they need to be informed immediately. And I know, especially on the death cases, they do not like to have any kind of delay. They want to know about that. They want to know about that right away. So it is the existence of a COVID-19 case at the workplace and the injury that results that has to be reported. It has to be reported even if the cause of COVID-19 was not work-related. An individual may be hospitalized for COVID-19, and they may admit that their exposure was from their family because they have 3 family members at home that were sick first. No one else at the place of employment was sick, and then they became ill. So it's still information. They still count as a COVID case. It's a COVID case in the workplace. All the precautions have to be taken, and the reporting would still have to be done, even if it's not work related. Remember, nearly half of the claims for COVID-19 that are filed, where there's a claim form that comes in where it's claimed that this is a work-related injury, about half of those are actually denied for one reason or another. They don't meet the presumption, or circumstances exist where that presumption can be rebutted. So in those particular cases that may not be work-related, which is fine for workers' compensation purposes, for Cal OSHA though, it's still considered a case and still would have to be reported. We go to the next slide. Tracking cases, again, this is later on in the regulations where there is a little bit more information that you need to collect in addition to name, work location, date symptoms started, and when symptoms may have stopped. But you also have to look at the last day that an individual worked, and you need to make sure that you keep this information and only disseminate the information as required to by law, and that's going to vary based upon the entity. You tell your claims administrator some information, you tell your employees other information, and then you tell the health department even more information at that point. So it's important to keep those in mind. Best thing to remember, don't tell anybody someone's name unless a government agency is asking for it. We can go to the next slide. And we can go to the next slide. That slide, essentially, there is a regulation that says if you have COVID-19, you can't be at work. And you would think that that's self-explanatory, but they did make sure that they put the regulation in there. Returning a COVID case to work. So once an individual has tested positive, they've had COVID-19, they've been out of the workplace, what are the requirements for them to come back to work? The requirements are that they not have a fever within 24 hours, that their COVID-19 symptoms have improved, and that it's been at least 10 days since their symptoms first appeared. And remember, this is one of the particular regulations that can be amended by your local health authority. So if they've changed the 10 days, or if they've changed any of the other requirements for returning to work, individuals can then be returned to work perhaps sooner than these regulations would require. But something else to remember, though, you cannot require a negative test in order for an employee to return back to work. That is specifically listed in the regulations, and that is something that it is interesting, and many people don't know it, so I do like to say it several times, that a negative test cannot be required by an employer in order for an individual to return to work. And we go to the next slide. Wanted to make sure we hit the outbreak section. So what is an outbreak? An outbreak here is going to be different than an outbreak for workers' compensation purposes, which was either the 4 or 4% rule. Here in this case, it's 3 cases. So it's 3 cases within a 14-day window. It doesn't say anything about the size of the employer or anything about percentages. So this may be hit very, very frequently, or in fact constantly. If you have a facility that perhaps has 1,000 people working there, it's very likely that you're going to have 3 COVID cases during a 14-day time frame. And once you do have an outbreak, then there are new outbreak rules that go into effect. Testing still has to be offered, but testing has to be offered on a more frequent basis. The outbreak continues so long as you continue to have individuals test positive within that 14-day time frame. You have to go 14 days with no positive tests in order for the outbreak to be considered over. We can hit the next slide. And I think we're going on, what the employers have to do. Provide testing. Testing has to be provided to all employees, and that testing may have to then be repeated within 1 week. This is a section that says employees shall be tested, which would seem to be mandatory. It would be best if Cal OSHA clarified that for us, because if there is a single case of COVID-19 in the workplace, testing has to be offered. If there is an outbreak, it says that employees shall be tested. And then the question would happen is, what happens if someone doesn't want to be tested, declines to be tested? That is a bit vague. And in fact, forcing someone to be tested is, of course, not an option, but you would want to be screening those individuals for potential symptoms going forward. Also, really quickly, going on to what is a major outbreak. And a major outbreak is considered to be a period of time within 30 days where you have 20 or more COVID-19 cases in the workplace. Major outbreaks also, like regular outbreaks, will continue for a 14-day time period. The outbreak is really meant to put into place the requirement that there be testing. You can go to the next slide. The testing is really what kicks in, because they want either weekly testing if there is an outbreak, or if there is a major outbreak, that may include twice a week testing or testing more often as needed. But each of these regulations, as it relates to what is an outbreak, then says you have to investigate, you have to determine whether or not there were some work conditions that caused this, and then they keep referring us back to the regular regulations. So the main change that comes when there is an outbreak is the requirements of testing. You may also have an outbreak, not just because of the number of individuals that have tested positive, but also if the health department declares there to be an outbreak, you may have an outbreak, and they may give you different orders in terms of how to abate that, how to reduce the number of cases, and that can include kind of changing the process or procedure for how work is even done. So, and that will also, of course, be very fact specific. So I know there may be additional questions regarding how these rules are implemented. Please feel free to ask. I know a lot of this is can be very fact specific in how these rules apply and what these rules actually mean. So I'm happy to provide any kind of further clarification as needed, answer questions regarding very specific situations or even hypothetical situations as needed. So please don't hesitate to reach out. You have our contact information, and don't forget, you can always email us also at covid@bradfordbarthel.com.
Thank you, Zane. I think Gemma may throw out a question or two really quick. I know we're running out of time here.
So one question that we had was, what notice is required if an employee is positive and another employee didn't work with them but was present in the workplace after them within a 24-hour period?
They would have had to come in contact with the individual. So you have to be in the exposed workplace during that high risk period, and that is defined as being within 6 feet for 15 minutes within a 24-hour period of time. So if that didn't happen, then they wouldn't have that direct exposure. If they are in the workplace, though, they need to be notified at least that they were present when there was another COVID case. You're right in that you may have situations where someone was at a particular place of employment and they test positive, and someone else may have also been there but may not have had any interaction. They do still need to be notified. Those requirements end if it's at a different work site altogether or a completely different location, such as the multi-story building. They only work on the 2nd floor. You don't necessarily have to tell the 12th floor. If you have multiple places of employment, you'd have to tell the one place of employment, but not a different location that might be 3 miles away. Was there another one?
We do have quite a few that we obviously didn't get to today because we were running short on time, and I'm sure that we will be getting answers to everybody. But there is one other one that was asked a couple of times. Is there any requirement to tell customers or the general public when there is a potential COVID exposure to customers or the general public.
And that was in the section on who you have to communicate with, because there is a reference to persons that is in there, but then it's later clarified to be employees, independent contractors, or the employees of other employers. So there's nothing specific on having to notify members of the public that there was specifically a COVID-19 case that was there. That is interesting because it does seem like that's something that the public might want to know about. You can also understand why businesses would not necessarily want to broadcast that particular bit of information out. But at present, the way the regulations are written, there is not that particular requirement. Okay, and we will get answers to the rest of the questions as well.
Thank you, Gemma, and thank you, Zane, so very much. I know there were, as Gemma mentioned, and Zane, a lot of questions, but I wanted to remind you that we do have some resources on our website that will help with some of these questions. Check out our blog. We have lots of articles on COVID. We have a new one on the OSHA regs, and we have a Q&A on the OSHA regs that's going to be coming out very soon. So do check those areas out. Thank you so much for joining us today. I hope you all stay healthy and have an absolutely wonderful afternoon. Take care.
Thank you so much. Bye-bye.
Thank you.